Fifth Amendment, the Takings Clause, which states, nor shall private property be taken without just compensation. If the government is going to do something to make my business, it's impossible for me to make money, then they have to compensate me for that. Okay? This is a merchant in the city of Baltimore. Does the Fifth Amendment apply to state governments? Does Baltimore, the city of Baltimore, have to compensate this merchant for making his business unprofitable? Moot, I guess. Here's what John Marshall says. Had the framers of the Bill of Rights intended them to be limitations on the powers of state governments, they would have imitated the framers of the original Constitution and have expressed that intention. So in the Constitution there are phrases, no state. It says that in the Constitution in various parts. And so John Marshall just logically deduces if the framers of the Bill of Rights had wanted them to apply to states, they would have said that too, no state. It is universally understood, John Marshall says. It is part of the history of the day that the Great Revolution, which established the Constitution of the United States, was not effected without immense opposition. In compliance with the sentiment thus generally expressed, to quiet fears thus extensively entertained, amendments were proposed by the required majority in Congress and adopted by the states. These amendments contain no expression indicating an intention to apply them to state governments. This court cannot so apply, right? It's universally understood. It's history today. John Marshall knows, right? He fought the Revolutionary War. He knows, Hamilton and Washington and these people. So, we know that the Bill of Rights doesn't. It must be nice, right, to be a Supreme Court justice and be interpreting the Constitution. And today we talk about 200 years later the intent of the framers. Must have been nice for John Marshall, right? He knows it's universally understood. He can say we can kind of believe it, unlike if Justice Kennedy says it's universally understood today. Well, I don't know about that. We're going to talk about Justice Kennedy later. We're going to get to him. And who is he, by the way? The most powerful person in the country, right? Maybe. 1833 to 1866. So, Barron versus Baltimore, the Supreme Court says no. The Bill of Rights does not apply to states. The framers did not intend it to. We all know this, okay? And it's logically deduced from the document itself. So what happens after Barron? What results after that decision? From the 1830s until the Civil War, Southern states made speech and publication critical of slavery a crime, for example, right? So, passing state legislatures abridging freedom of speech. A number of leading Republicans viewed these statutes as violations of the First Amendment and other provisions of the Constitution. Immediately after the Civil War, Republicans complained that Southern states were denying African Americans, Republicans, and loyalist citizens basic rights of speech and press, due process, bear arms, etc. The things that we think about in the Bill of Rights. So what do we do about this? Well, the North wins the war, right? So they get to dictate the terms of the victory, and one of the terms is the 14th Amendment, 1868. Now, the 14th Amendment has three provisions that we want to pay attention to. The first is the Privileges or Immunities Clause. So what does the 14th Amendment say? It says, no state shall. Okay, now that's important because the whole Civil War, right, you could say, is fought over this idea of states' rights, being able to do what they want to do, whether that's with regard to slavery or criminalizing speech or whatever it is, right? So the 14th Amendment is meant to correct this, and it begins very clearly, no state shall. And the Privileges or Immunities Clause says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. What are the privileges and immunities of citizens of the United States? Does the 14th Amendment then spell them out and list all 39 of them? Or 5 of them? Do you know what they might be? It doesn't say, by the way. I mean, just, what comes to mind? The privileges, what is a privilege that you have as a citizen of the United States? What is an immunity, protection that you have? I mean, clearly you have some privileges and some immunities, and now states can't deny those. Is it speech? I know you're looking at me going, I have no idea. Well, guess what? The Supreme Court has no idea either, so you're in good company. We'll talk about that in a second. All right, the second clause, the Due Process Clause. Nor shall any state deprive any person of life, liberty, or property without due process of law. Now, this appears in the Fifth Amendment to the Constitution, right? We talked about the Takings Clause being the Fifth Amendment. This also appears in the Fifth Amendment, right? It just doesn't say state, right? So this essentially, this is a restatement of the Fifth Amendment's due process clause, but it's in the 14th Amendment with the no state in the due process of law, right? What does that mean? Life, liberty, or property? Well, can the state of Pennsylvania take your life? Yes, but they have to give you due process first, right? Then they can off with your head if they want, right? Liberty, the freedom to move around. They can throw you in jail, they can lock you up, right? But you're going to get your due process, and then they're going to lock you up. Life, liberty, and property. They can take your property as well, right? We just talked about the takings clauses as one example. All right, so the Privileges and Immunities Clause, the Due Process Clause, and then finally the Equal Protection Clause, nor deny any person within its jurisdiction equal protection of the laws. What does that mean, equal protection of the laws? So that's it. The 14th Amendment doesn't spell out what this is. And this is a problem, or this is the genius of the Constitution, right? It's not specific. It's not a civil code. It's just phrases. And those phrases have to then be fought over by us for hundreds of years. So that's what we're going to do. We're going to go now through some of these phrases and see how they've been fought tooth and nail by Supreme Court justices, and why these fights take place in the Supreme Court. Because they're the smartest people, right? They're the wisest, and it's good to have 9 wise, smart, neutral, objective, impartial people deciding these very difficult questions. Like this guy, Samuel Freeman Miller. Look at him. Doesn't he look neutral? He's very impartial to me. All right, so the Slaughterhouse cases in 1873 is the first time the Supreme Court is going to interpret this brand new 14th Amendment, right? And specifically the Privileges and Immunities Clause. And the question is, does the Privileges or Immunities Clause, right? What are the privileges and immunities that states can't deny? It's the Bill of Rights. That seems like a logical argument, and that's what the attorneys are saying in the Slaughterhouse cases to the Supreme Court. They're saying that's what those who framed the 14th Amendment and passed it, that's what they meant. The privileges and immunities of citizens of the United States are those that are listed in the Bill of Rights. And therefore no state can deny them. Now, if the court had answered yes, we'd be done. There'd be no more lecture. The incorporation lecture would end. But they did not answer yes. Justice Miller writes, "We are convinced that no such results were intended by the Congress which proposed these amendments, nor by the legislatures of the states which ratified them." So when you talk about the intent of the framers, is it those who wrote them, who passed them in Congress, those who ratified them in the states? They look everywhere for evidence that this was the intent of the people involved in the ratification of the 14th Amendment. They can't find it. That that's not the intention of the 14th Amendment. Miller's opinion, and you can read it, it's long and convoluted, and it's close. It's a 5-4 decision in the Slaughterhouse case. It's amazing to think that a 5-4 decision has never been overturned. I mean, this case is still the law today. And this opinion had the effect of rendering the Privileges or Immunities Clause virtually useless, a condition that has changed little since then. Today, the clause remains a virtual non-starter in the law. If you're an attorney and you go trying to argue the Privileges and Immunities Clause in some case, the justices are going to be like, "Are you serious?" Because it just isn't going anywhere. Yeah.
What part of the country is he from?
Oh, this is a tough one. Freeman Miller. That's a good question. Who knows the answer to that one? I don't know. We're going to have to look up. Do we have online access on this thing?
It's not set up now, but we could.
Yeah, maybe we can figure this out over the break. Yeah, it's an interesting question to look at these justices after the Civil War, right, during this era of Reconstruction on the court. They're very pro-North, but there are certainly divisions on the court, and it is interesting to look at that. And I can't, off the top of my head, I don't know. But look, the court is divided 5-4 on this issue, and there are justices that do believe that the Privileges and Immunities Clause means something, and these justices are essentially saying it doesn't mean that. And to this day, it's literally, I'm not kidding, there's no law on the privilege. It means nothing. It's hard for me to believe. When I learned that in college, I was like, no way, how can that seems like the most important part of the 14th Amendment. But it's not, it's meaningless. It's because judges said so. All right, let's talk about Hurtado versus California, 1884. So the court had a chance there in the Slaughterhouse cases to incorporate the Bill of Rights. It said no. So lawyers kept trying to argue this Privileges and Immunities Clause position, and they kept losing, and so they switched strategy like good lawyers do. That's not working, the court's not buying it. Let's try another vehicle in the law, right, to get the Bill of Rights incorporated and applied to the states. And so in Hurtado versus California in 1884, the question is, does the Due Process Clause of the 14th Amendment incorporate the Bill of Rights? The Due Process Clause, right? Nor shall any state deny due process, or deny life, liberty, or property without due process of law. What does that mean? I mean, I gave you some examples, right? Life, liberty, and property without due process of law. But what does liberty mean? I gave you the example of movement, freedom of movement, right? Throwing you in jail. But what about freedom to speak, right? Is that a liberty? Free speech. And so, what is the, so this is a little bit trickier, maybe more of a reach than perhaps privileges and immunities in terms of trying to figure out whether this clause of the 14th Amendment incorporates all those provisions of the Bill of Rights. But the lawyers have no other choice. They have nowhere else to go. So they go to the Due Process Clause and they make this argument. In this case, and this was a criminal procedure case, it involved a state prosecution of murder without a grand jury indictment, right? So the Bill of Rights says that you know, presentment of a grand jury, which I can't remember which amendment that is now. I got all those questions wrong, by the way. That those amendment questions. I don't know which amendment it is. I was at Turing, no, not sure. I know it's in there. I kept saying it's in there. But there's a grand jury. So the Sixth Amendment, there's a guarantee, right? A grand jury guarantee. So this is a California case where there was no grand jury. This guy was indicted without a grand jury indictment for murder. Fifth Amendment states no person shall be held to answer. Oh, the Fifth Amendment there. That's why I put it on here. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, nor be deprived of life, liberty, or property under due process law. So there's that due process clause, right, that I mentioned before in the Fifth Amendment, after the grand jury provision. Interesting, because these lawyers are arguing in Hurtado that the 14th Amendment's due process clause incorporates the Fifth Amendment. You're starting to think this is bullshit, right? There's no, I'm sorry, did I say that? That's right, freedom of speech. All right. Does the Fifth Amendment's protection of a grand jury apply to state governments? That's the question. And what's the answer? This is, you know, this is why when my students take the law school admissions test and there's all these logical reasoning questions on it, this is an exercise in logic. Okay? The court explained that unlike the 14th Amendment, the Fifth Amendment states that persons are guaranteed both due process and grand jury. They're listed separately. Since the 14th Amendment only lists due process, grand jury indictment is not part of that phrase. It's something separate from due process. Right? In other words, if due process meant grand jury, then we wouldn't have had to list it separately. We would all just know that that's what it meant. But since the framers listed it separately, they knew it wasn't part of due process, and therefore it can't be incorporated by the 14th. Did you get that? Do you see the logic there? Genius, see? I bet you Justice Matthews did well on the law school admissions test. He probably aced the logical reasoning section. So the grand jury provision is not incorporated. And guess what? To this day, it's still not incorporated. State governments do not. Now, they can choose to have grand jury for capital cases if they want, but they don't have to. This is still good law today in Hurtado versus California. Yay!
So I'm trying to figure out here whether these guys are Justice Matthews is talking about decided law, changing other decided law, because I don't ever recall anybody telling me that the 14th Amendment preempts the 5th Amendment in regards to due process. Maybe that's what you're saying, and I'm just not getting it, but I'm not hearing it.
Well, what do you mean by preempt exactly?
Supersede.
Supersede. Yeah, I mean, how does one read the Fifth Amendment? In other words, that phrase, due process of law, at the end of it, does that just sum up all the things we just mentioned in the Fifth Amendment? Or is it something separate from all the things we just mentioned?
So intent is what's bothering me.
Yes! What is the intent of James Madison?
Well, the framers originally intended this to protect, not for it to be done away with
No.
by later amendments.
John Marshall said that the framers only intended this to be protection against the United States government. Right? This Fifth Amendment.
Yeah, but then you come along and say states. But how the hell can they construe that to mean that we could be selective in whether we say that this is going to be this way or that way?
This is an interesting game, isn't it? The constitutional law. I love it. I love it because my students come into my classes thinking, I want to be a lawyer because there's got to be a right answer, right? I get a lot of navigators who actually come in wanting to go to law school because they like the logical, they think there's a right answer, that there's going to be an answer. And I'll tell you what, my classes are not about that. I'm a political scientist. I teach law because it's politics, because there's not a right answer, right? We can disagree on the answer, but there's plausible, right? We can understand the argument of John Marshall. It's a plausible argument that the Bill of Rights doesn't apply to states. We can disagree with it, but it makes sense. It's a plausible argument. This is a plausible argument, whether we agree with it or not. So that's what I like about it. It's really good, it's good debate material. So this is good. I like the way you're thinking here. Just wait, it gets far worse. If only we could just stop at Hurtado and have this discussion. No. Okay, so the 14th Amendment due process clause does not incorporate the 5th Amendment's grand jury protection. All right, Chicago, Burlington, and Quincy Railroad, 1897. 1897, all right? The case involved takes clause of the 5th Amendment again, just like in Barron versus Baltimore. Chicago took railroad property, the city of Chicago, but paid the companies $1, right? Nor shall private property be taken without just compensation. Is that just compensation, $1 for the railroads, right? Private railroad company? No, is the answer, so you sue, right? Remember in Barron versus Baltimore, you couldn't sue the city of Baltimore, so how can you sue the city of Chicago for a takings violation? Well, attorneys now argue the 14th Amendment's due process clause incorporates the 5th Amendment's takings clause. Right? The court held the takings clause constituted, quote, a vital principle of Republican institutions, without which almost all other rights would become worthless. The railroad companies won, but more importantly, for the first time, the court incorporated a clause contained in the Bill of Rights. So there you have it. Why is the 5th Amendment takings clause incorporated but not the 6th Amendment grand jury provisions? Because one is a vital principle of Republican institutions, and the other one is not. Who says so? We say so. The wise, neutral, objective justices of the Supreme Court. Yet in the next incorporation case, Maxwell versus Dow in 1900, a state criminal defendant was denied a grand jury indictment and was tried by an 8-person jury rather than the traditional 12 angry men, right? All right. I still show that the old black and white Henry Fonda film in my judicial process class, and I show that. And have you seen that recently? If you haven't seen that movie, you've got to see it. Who has not? I'm not going to say it. I'm not going to say it, because if you haven't seen it, you need to go see this, because there's a scene in there that the kids still scream to this day, right? Where Henry Fonda turns around the jury table by doing something dramatic, and you have to see that. You can show this in class. All right, so Maxwell versus Dow. The court refused to incorporate protections listed in the 5th and 6th Amendments, holding that trial by jury has never been affirmed to be a necessary requisite of due process of law. How about that? Trial by jury has never been part of that due process of law phrase. You don't have to get a trial by a jury. No. Now, if the state wants to let you have one, whether it be 8 or 12, well, that's very nice, isn't it? But they don't have to in order to comport with ideas of due process of law. You have to get some kind of process. Maybe a judge will conduct a trial, right, and decide innocence or guilt. I don't know. Maybe the governor. All right, Twining versus New Jersey, 1908. Now a standard begins to emerge. We talk about vital principles of Republican governments. Is that the guidepost we're going to use to decide which provisions of the Bill of Rights are incorporated to the states? Well, in Twining versus New Jersey, the court starts to articulate more fully a standard to help guide us. And the court says, Justice Moody, it is possible that some of the personal rights safeguarded by the first 8 amendments against national action may also be safeguarded against state action, because a denial of them would be a denial of due process of law. If this is so, it is not because those rights are enumerated in the first 8 amendments, but because they are of such a nature that they are included in the conception of due process of law. This court has always declined to give a comprehensive definition of it, and has preferred that its full meaning should be gradually ascertained by the process of inclusion and exclusion in the course of the decisions of the cases as they arise. So, selective incorporation. It's possible that the Bill of Rights may apply to the states, but we're not going to sit here and tell you now once and for all whether they all do or don't, which ones do and which ones don't. What we've seen in the past with Chicago, Burlington, and Quincy Railroad, and Maxwell versus Dallas, the court is going to consider these on a piecemeal basis, one by one, as they come up. That's what the court is saying here in 20 versus 3. That's what we're going to do. We're going to do selective incorporation. Okay? So in Gidlow versus New York in 1925 now, the court says, for present purposes, we may and do assume that freedom of speech and of the press are among the fundamental civil rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. Reasonably limited, this freedom is an inestimable privilege in a free government. So in 1925, finally, state governments and local governments couldn't pass laws abridging freedom of speech and the press. So the guarantees in the First Amendment, Pennsylvania is now held to those as of 1925. Yay! My students are always like, what? 1925? That recent? I mean, all right. How about Palco versus Connecticut, 1937? Justice Cardozo says, the Due Process Clause of the 14th Amendment incorporates those rights which are implicit in the concept of ordered liberty, and which constitute the very essence of a scheme of ordered liberty. So how will we know which ones should be incorporated and which ones are not? What is our standard? What is our test in future cases that may come before us? We're going to ask, when an amendment is petitioned to us to be incorporated to the states, is this implicit in the concept of ordered liberty? And if it is, then we will incorporate it. And if it's not, then we won't. Isn't it so clear? An 8-year-old can figure this out, right? This would be good. Give your students a list of various provisions of the Bill of Rights and ask them which ones are implicit in the concept of ordered liberty. See if they all agree. If the 14th Amendment has absorbed them, the process of absorption has had its source in the belief that neither liberty nor justice would exist if they were sacrificed. So that's a little help. You could add a little cheat sheet for it, right? Neither liberty nor justice would exist if they were sacrificed. So, in other words, if we don't incorporate this, could we still have liberty and justice? And if the answer is yes, like trial by jury, for example, we can still have liberty and justice without trial by jury. We have trial by somebody else. We can still have liberty and justice. Then the answer is we don't need to incorporate it. Right? Genius. That's smart. All right, applying the Palco standard implicit in the concept of ordered liberty. The court continued to selectively incorporate provisions of the Bill of Rights. This was a compromise position among various members of the court. So some members of the court said, no, the 14th Amendment incorporates all of the Bill of Rights. Some of them said, no, the selective process is the right process. Others said, not only could it possibly incorporate all the Bill of Rights, there might be more to it than just the Bill of Rights. Let's not limit ourselves to the Bill of Rights. There might be other rights that are not even listed in the Bill of Rights that might be applied to state governments through due process, right? Liberty interests that aren't even listed there. So it starts to get real messy around this time. So you have justices like Hugo Black and William O. Douglas arguing that the 14th Amendment intended to make all of the provisions of the Bill of Rights applicable to the states. Total incorporation, right? Moderate conservative justices like Justice Harlan and Justice Stewart said that the due process guaranteed by the 14th Amendment was meant neither to incorporate nor to be limited to specific guarantees of the Bill of Rights. So we'll just have to figure this out one by one as they come up and not be held just to the Bill of Rights. Okay, so what do we have today? Today, essentially, all of the important provisions of the Bill of Rights have been incorporated. That's good. Breathe a sigh of relief, right? Some have not. So, First Amendment. All the provisions of the First Amendment, speech, press, assembly, religion, all incorporated in various cases over time. Okay? Second Amendment, The right to bear arms, the court rejected incorporation in 1876 and then dodged the issue in DC versus Heller in 2008. Americans didn't realize that. I thought this was the most fascinating part of the case. Why did the Supreme Court agree to take the gun control case from the District of Columbia and not from Chicago or some other place in America? Why did they do that?
Remove the federalism issue.
It removed the incorporation question from the table. And so we knew they weren't going to take a case involving a state or local law, right? That they would take a DC law, because there's no question that that only then involves, that doesn't involve the 14th Amendment. It involves the 5th Amendment, whatever. And so the court dodged the issue. And the reason they did that is because there are justices on the Supreme Court who are in favor of Second Amendment rights. Conservative justices, right, who read the Constitution to mean a right for individuals to have guns, but who don't believe in this incorporation fiction that they think activist liberal judges have forced upon us. How are they going to reconcile that then when a Second Amendment gun case comes before them from the state or local government? Right? What are they going to do? So if they only take a case that only involves the federal government, then they don't have to deal with that issue. It's much easier for them. So this DC versus Heller case doesn't solve the issue. Now what will probably happen is a state or local law will be challenged, and it will get to the Court of Appeals, and one of these Court of Appeals decisions, or many Court of Appeals decisions, will take the principles of Heller and apply it to state and local laws. They'll incorporate it that way, and the Supreme Court will just never take that case. And so they'll never have to get to it, right? And so it will be incorporated by the lower court case. That's what's going to happen. Why? Because the Supreme Court is all about politics. All right, Third Amendment. No Supreme Court decision on this. And this is what happened to the Third Amendment, right? This is the Quartering of Soldiers Amendment. The Second Circuit found it to be incorporated. So that's what's going to happen probably with the Second Amendment. The Supreme Court will not incorporate it. Some Court of Appeals will do it. The court will just let that ruling stand. Okay? Fourth Amendment is fully incorporated. We're going to talk about search and seizure. Is that the Fourth Amendment? Later? These things. The Fifth Amendment is incorporated except for the clause guaranteeing criminal prosecution only by grand jury indictment, the one that I mentioned before. So all the provisions of the Fifth Amendment, takings clause, all of them, right, incorporated except grand jury indictment. So you can add, if you allegedly commit murder in a state, they don't need to have a grand jury indictment to seek the death penalty or something like that, right? To prosecute and seek the death. They don't need a grand jury indictment. They can just have other processes, other means by which to indict and prosecute. And that still gives you some type of due process. Sixth Amendment is fully incorporated. The Seventh Amendment is not incorporated. The Eighth Amendment, we're going to talk about that. It's going to be the last actually, the death penalty one we're going to talk about. Oh, that's going to be fun. Wait till we get to the death penalty. That is incorporated with respect to the protection against cruel and unusual punishment, which is the thing that we most are interested in, the thing that we're going to talk about later on. But there's no Supreme Court ruling on the incorporation of excessive fines or excessive bail provisions that Brett mentioned earlier. So that has not been incorporated yet. Okay. So that's where we are today. So it's, is this even an issue? I have a colleague and I are doing a paper on this. We're trying to, who knows, we might do a book on incorporation. We're trying to get a handle on this and why do some amendments get incorporated, why do they not? What triggers, and I think DC versus Heller is why we're interested in this. What's going on here? I mean, I don't know whether it matters or not that we even look into this, because there's not a whole lot left here. But I think it's an interesting question. But this maybe is why I'm in the ivory tower, right? Because that's what we do, is throw out and write about esoteric stuff that nobody cares about and sell free copies. My mom buys free copies. Okay. Now, in the 1980s, the new right political regime attacked incorporation. I mentioned a second ago. Attorney General Edwin Meese and others criticized incorporation as inconsistent with the intent of the framers. So you're sort of mentioning, look, if the framers didn't intend this, then what are we doing messing around? It's pretty clear to John Marshall, right, who was no friend of states' rights in the 1830s, it was clear to him that the framers didn't intend incorporation. And it's pretty clear to historians that it wasn't intended. We talked about James Madison's proposed amendment where he says no state. Pretty clear. Then maybe we should reverse this incorporation and overturn these decisions that incorporate and get it right. Right? Listen to what Clarence Thomas says. He explained in one Congress shall make no law right respecting an establishment of religion. Thomas explained, the text and history of the Establishment Clause strongly suggest that it is a federalism provision intended to prevent Congress from interfering with state establishments. Thus, it makes little sense to incorporate the Establishment Clause. Because the way Thomas is saying, the way I read all the history of what the framers intended by putting that Establishment Clause in, is they wanted to prevent Congress from meddling with states, with what states are doing with regard to religion. That's what he believes. So does that mean then Pennsylvania can set up a church? The state church of Pennsylvania? I mean, given what Thomas is telling us about his understanding of the Establishment Clause, this is just one example of how this incorporation nonsense is fiction. It's judicial fiction, right? And if we really are true to the intent of the framers and really are true to applying the Constitution the way it's written, and don't get Justice Thomas wrong, if you don't like the Constitution, then amend it, and he'll be happy to apply the amendments appropriately. But don't use the due process clause of the 14th Amendment to incorporate the Establishment Clause, right? So the question is, would Clarence Thomas, he's just suggesting this in some of these establishment opinions that come down. If the court was asked on its face to overturn the case that incorporated the Establishment Clause, would they do it? Right? I mean, people talk about Justice Scalia being conservative, and he's not as conservative as Thomas. Thomas will go further. And so when you think about voting for president, did you see that Colin Powell thing on Meet the Press the other day? He mentioned judges. I was shocked. Right? Because I teach constitutional law, so I'm always getting my students to think about, the president appoints judges, not only the Supreme Court, but all the federal courts. And maybe that, if you're not sure which way to go, think about the kind of judges you might want. And I think that's what Powell was saying. And so, if you like this, then it should be pretty clear who you're voting for, right? This is a conservative position. And so there should be absolutely no question who you want to vote for. All right, so let's conclude. The theory of selective incorporation in concept emerged the victor, but for all practical purposes and with only a few exceptions, total nationalization has prevailed. The liberal activists have won, right? As a result, present reading of the Constitution now assures that the basic civil liberties of citizens of the United States are uniformly protected against infringement by any government entity, federal, state, or local. Should we overturn all of them? Restore the Constitution to its original intent? Or maybe you want to actually overturn Slaughterhouse and say it's the Privileges and Immunities Clause that incorporates all the amendments. And so go ahead and overturn all the cases with you. That would be fun. I'd like to see that. I want this stuff to happen. I want the Supreme Court to go nuts. Some good teaching material. But if you don't understand this stuff about incorporation, then it's hard to understand, like later on, when we're going to talk about search and seizure, we're going to talk about the case that incorporated the search and seizure provision to the states. Then there's another case that didn't incorporate the exclusionary rule. So search and seizure was incorporated, but the exclusionary rule was not. So if you don't understand incorporation, then you'll be lost. You'll be lost in understanding what the court is doing in D.C. versus Heller. You're not getting the full picture, right? What we're going to say.
I was kind of curious, and you haven't mentioned it yet, and it's usually referred to in a different context of equal rights. But the Equal Protection Clause, when conjoined with the Due Process Clause together, doesn't that imply that the federal clause right there isn't the implication that the Federal Bill of Rights is being established to ensure that no individual state violates what are considered to be, as you mentioned, the religious immunity of any citizen anywhere in the United States. And I'm curious why that argument's never been made.
Well, you want to say a little more about that? The Equal Protection Clause, I mean, what do you get?
They use the Equal Protection Clause to establish the basis of civil rights legislation.
Right.
But I'm curious why they didn't go a step further and use that clause to argue that it implies the Due Process Clause automatically
In other words, everyone has the right to freedom of speech because the Equal Protection Clause
guarantees.
everyone to be treated equally with regard to their rights. I mean, I guess you run into still the same problem, right? Which rights, right, are you guaranteed under
Where does that
protection?
establish that you go basically by the state standard. So whatever a state passes suddenly becomes the standard for the whole nation.
It's fascinating. When I get a question like this from a student, I think, you're a lawyer, that's it, right? I mean, because that's the kind of way, that's kind of thinking that lawyers do. They think, well, what about the equal protection clause? Maybe that's where we could ground our enterprise to try to incorporate the Bill of Rights of the states, right? And that's why people either want to be lawyers or they hate lawyers, right? Because it either sounds like a fun project, let's think about this is interesting, let's make this argument a legal brief, let's win a case, let's change the law, or you think lawyers are a bunch of shysters, right? They're just using the law to get their own preferred, policy preferences, and, it's judicial activism at its worst, using the equal protection clause to incorporate the Bill of Rights. Oh, Justice Thomas is going to just go nuts. Don't tell him you said that. You hate that. Yeah.
I'm wondering what the role of the Ninth Amendment is in this, because some people.
How can you bring this up? Are you crazy? Do you know what the Ninth Amendment says? There are other rights that aren't listed. So that amendment has essentially, like the privilege and immunities clause, been gutted. It has been left alone. Only rarely have justices, like in the right to privacy cases, right? Griswold versus Connecticut, some justices have suggested that maybe the right to privacy is one of these unenumerated rights that the framers were getting at in the Ninth Amendment. But the other justices criticize those justices and say, well, okay, which other rights are they? Just the ones you like. You like the right to privacy, you like the right to an abortion, that must be all in the Ninth Amendment, right? So who's to say which rights are not enumerated? So it's kind of like, that's a scary amendment to start rounding rights on, because it just says there are other rights that exist. There aren't rights.
The premise of the Ninth is originally something that want to list, as soon as you list rights, and it's like, what's not on your list, something that want to list rights, because these were perceived as natural rights, and that is a part of the, original intent. So, that's why the blank check of the Ninth Amendment was included. So that's never really been, aside from like Griswold or Grove, that's never really been.
That's right. That's why I think it's good to have 9 wise, objective, neutral justices who are very wise, because they can tell us what's in the Ninth Amendment. Because I don't. But they do, right? Justice Kennedy knows, and he will tell you. He's not afraid to tell you. He's not afraid to be bold, right? You raised a good question. We're going to keep going back to this idea of, I think you're getting at this larger point.
How about the supremacy article in the Constitution that ever brought into these arguments?
The supremacy clause?
Yeah.
What do you mean by that? What do you mean by the supremacy clause? You're right. Certainly it has come up over time, and John Marshall relied on it in some early decisions. But I think the question is a federalism question, right? It's about, what is America about? Every semester I teach constitutional law cases about federalism, and that's what incorporation is about. And I think that in order to understand America, you've got to understand this division between the national government and the state governments, right? Divided power. That's what we have in America. So the supremacy clause is one of these issues about how we allocate power in America. Has the supremacy clause give the national government authority to do whatever it wants? And the answer is no. We have 200 years of Supreme Court decisions debating that. Sometimes it does, sometimes it doesn't, and it depends. But that's really what America is about. And if you want to talk about the Civil War, certainly slavery is the issue. But it's this idea that states can decide for themselves whether to have slavery, whether to be slave states, and Congress can't tell us, right? So it's federalism. What is abortion? It's a federalism question. If Roe versus Wade is overturned, guess what? My students think, oh my God, there'll be no more abortions in America, right? It'll be criminalized. No, it's up to states to decide, right? So that's what America is. It's this question of should there be national rights or laws, or should they be left to state and local governments? That's the overriding fundamental question for America. I think you've got to understand that, right? And again, if you're looking at the differences between the 2 major candidates, the 2 presidential candidates, they have very different ideas about federalism, and I would love to see people ask those kind of questions, right? Then you can probably make your mind easier about who to vote for. Because one would very much go more towards states' rights, and one would be more towards national power, and it does depend on the issue. But I think you're absolutely getting at a key question in interpreting the Constitution. It depends on your vision. If you're more into states' rights, then you're going to have a different vision of the Constitution. So this incorporation has been done by the nationalist liberal justices, right? That's what's going on here. Yeah.
It seems that if Obama becomes president, it'll be a 5-4 conservative majority in the Supreme Court, but if McCain becomes president, it's most likely going to be a 7-2 conservative majority. Do you know, have you thought of any of the possible implications of that?
Ah, I love this. This is, yeah, maybe we should wait and talk more about this later on, because I do want to address this. After the final lecture on the death penalty, I want to talk about John Paul Stevens. You know when John Paul Stevens was born? 1920. My students are like, 1920? That was before incorporation. The First Amendment. Yeah, so he's going, okay? He's leaving. He's been waiting for 8 years, right? So he wants President Obama to appoint his replacement. Will Justice Souter, will Ruth Bader Ginsburg, the other liberals leave? We're gonna, because you're right, the court is 5-4 on a lot of these cases, and we're gonna talk. So let's wait, let's save that for the death penalty question. Because I think we're out of time.
We're out of time.
Sorry.
I'm sorry. Thank you.
You have to stop me.
No, that's actually your timing was good. That's what I was just saying. For those of you who are wondering about that first judge, Scott went and did what we all do. He Googled it. Okay? Samuel Freeman Miller, who said you can't incorporate using the 14th Amendment. Obviously, from where?
The South.
Born in Kentucky, border state, moved and lived his life in Iowa. Okay, are we getting even more confused? Ready for this? He is known as a religious liberal. And guess who appointed him to the Supreme Court? Abraham Lincoln.
Ooh.
It's the Supreme Court! It doesn't, I mean, it's just like, you know, I'm one of these guys, when I look at the court, you know, it's very easy to snap into that media-driven liberal conservative thing. I had the ridiculous pleasure one time of actually having Justice Thomas stumble into a group of 13 teachers I was working with at Mount Vernon on the day we were talking about federalism. Okay, talking about absolute perfect time and perfect storm. He took a look at the notes, smiled, and said, "You're talking about federalism." I said, "Yeah." He said, "Sit down." I went, "Yes, sir." The best thing was he turned around, looked at those teachers, and said, "So what do you think?" At which point I laughed and said, "Come on. Do you really expect them to tell the Supreme Court justice what they think? Tell them what you think." His first words out of his mouth were, "There is no right to privacy in the Constitution of the United States." So let's start there. And he pointed out, he said, "Everybody calls me conservative. I'm an originalist," which is what he's reading with the 14th Amendment and the Establishment Clause. He talked about the Establishment Clause. He said the reason that he doesn't think it works is because the reason they wrote it that way is 5 states had established religions at the time that the First Amendment was written, and the country, the Congress, did not want to strike down those states' religions. Okay? One of them being Virginia, another one being Massachusetts, which had the longest standing established religion in the country, until what, 1808, somewhere around there, they finally disestablished religion. But he also talked about, he said, the reason you can tell I'm an originalist is this. Kelo versus New London, right? Protection of property against eminent domain takers. So, being a good conservative, strong defender of private property, which way did he vote? He voted to allow New London, Connecticut to take the land. Why? It's a local issue. The local state can make that up. Raich versus California. Medical marijuana in California. Being good staunch conservative against the spread of illegal drugs across the country, he voted to let California have medical marijuana. Why? That's a state issue. That's a state experiment. That's what they should be able to do. He has this strict construction of federalism that unless it says it in the document, the states have the authority, the power to do it. Which is a really different way of looking at things. But he ends up on opposite sides. And like he'll point out, he said, if it's an issue that deals with whether or not a state can do it, I really don't care. Not really don't care. I really don't think about whether or not the value involved. I think about whether or not, when I looked at that document, was that something that the framers said, this is a national issue? And if they didn't, I'm going to let the states do it. I think if a prostitution case came in front of me, he'd say, state authority. Okay? It's a different way of looking at things, and he's a very different guy. Matter of fact, if you end up at our agreed to speak to our group at our awards dinner for the essay contest Being an American, which is really strange because Justice Thomas usually does not speak to large groups at all. He'll speak to small groups. One of the groups he loves to speak to is teachers. He loves talking to teachers. But he won't talk to big groups. He doesn't like to talk. He likes to have private events. So, it's a different kind of guy. Let's take a look at the book. Let's take a look at the book. Are you going to tell the laugh the story later about time? No, okay. I don't want to steal it. Or as Brendan. As we look at the Supreme Court, and when we look at these decisions, two things to remember. Here, Blackman, Warren Court, said the Supreme Court is not final because we're right. We're right because we're final. That's the reason we're right. Nobody can disagree with us. If we make a decision, we're right. Another justice, Justice Brennan, used to bring his law clerks in. You know, these bright guys, these #1 graduates from Yale and Harvard and, you know, the great law schools across the nation. And he'd bring them in before every session and take them into one of the conference rooms. And he'd sit them down and he'd say, all right, before we get started, I want you all to tell me what is the most important word at the Supreme Court of the United States. And of course, these brilliant legal minds would sit around and talk about justice, fairness, equality, right, liberty. And he'd sit there and listen to them make their decisions, and then he'd look at them and say, no, no. And he'd let them have they'd brainstorm all these great ideas, and he'd look at them after they finally realized he had something he wanted to tell them. And he wanted them to listen. They'd quiet down and say, okay, I'm going to tell you what the most important word at the Supreme Court is. The most important word at the Supreme Court is 5. And whatever you do for me, whatever you write for me, understand, I don't care how brilliant it is, I don't care how great a reflection of justice in America it is, if I can't get 4 other justices to agree with me, I'm not going to read it. 5. What you write for me won't get 4 other on board, don't even bother. So the brilliant, unopinionated, straightforward, neutral men and women who serve on the court know exactly what they're doing. They're in groups with 9 people who get to make decisions. And by the way, just because those 3 retire, if the Senate goes strongly Democratic, how many people will be on the Supreme Court if they retire? 6, because the Senate won't take up any of their appointments. Be that simple. They'll just not listen until you send somebody that they're willing to talk about. They're supposed to maybe get 60. If they get 60, that could happen. They get a filibuster-proof Senate. They just don't have to take it up. Justice Stevens could die. There'd be an 8-member court because the Senate says, I'm sorry, not even going to make it to a hearing. They could do that either way if they wanted. It's one of the wonders of our 3-pronged system. Okay, this book, a lot of you have seen it before. If you haven't seen it before, this is designed for less academically inclined students. Who are we talking about? We're talking about the kids who don't like to read. That simple, okay? We're talking about kids who don't like to read. Does that mean that these lessons are too easy for upper level? No. Just means you're going to have to give them a little bit more in. And we'll talk about that as we move forward. They are written at an 8th grade reading level. Does that mean this is an 8th grade book? No, it's a high school level text. Okay? It's a high school level set of lessons. We're dealing with abstract ideas. We're dealing with Supreme Court decisions. We're dealing with looking at the values underlying the founding documents of the country. You can use this in an 8th grade classroom, but you will be pushing them. Okay? It is designed for a high school level student, high school level thinking with 8th grade level reading. And I know none of you have those people because all the kids here, this is the Lake Wobegon of the United States. All of your children are above average, right? And you're still trying to figure out how that became national policy with No Child Left Behind. You don't know how we can all be above average. That just means you're all average. But we'll move forward. Okay, strong literacy, media literacy component. Again, we're not looking for real solid or strong critical thinking skills here. We're not looking for a lot of evaluation. We're looking for the ability to process the information. We're looking for the ability to understand what the concepts are, and then we're going to move forward from there. Okay? And research-based best teaching practices, that's what we talked about before with the Carnegie Corporation. We're also using high-level teachers, who know what they're doing out in the classrooms to do these lessons. Okay? The book itself, if you just open it to Unit 1, Lesson 1, which is the Founder's Lesson, we can look at it this way. First of all, those of you who didn't realize you can cheat on page Roman numeral 5, the Bill of Rights, it's right there, but I didn't tell you that. Taking the lesson. If you look at page 3, Unit Introduction, what we're going to do is tell you what's in the unit. We're also going to lay out, in any other unit besides this one, we're going to lay out which of the amendments we're discussing in that unit. Which amendments, which sections of those amendments are we going to be looking at. In this case, we're looking at where this thing came from. We're going to lay out the unit objectives. Okay? And then we're going to give you thumbnail sketches on that page. If you turn the page, you will see the lesson plan, the lesson overview, okay, and the lesson plan. Very detailed lesson plan designed that if you were not in the classroom and a qualified substitute was available, that qualified substitute, if you had all the materials sitting there for them, should be able to teach this lesson with minimal preparation, even if they don't know this information. Why? Because we're going to give them an answer key that they can look at. So if we're teaching a lesson on the Fourth Amendment and your sub is a world history teacher and they're looking at you going search and seizure, I think I'm going to be sick too. Okay? You tell them, no, look, I've got an entire lesson for you. Look at what the lesson plan says. Look at what the answers are. You can still get the kids where we need to be. That's the whole concept of the lesson plan. The handouts are there. The DVDs are in the front of the book. The DVDs can be burned onto your shared drive. I will tell you this, however, if you burn them on the shared drive, they burn in chapters, which means all the DVDs for each of the units comes out at one time, and you can't pick between them. Okay, so if you know somebody with a DVD burner, the best way to do it is to stick this thing in, record each unit separately, and then throw it on your shared drive. And not that I would encourage that, but like I said, if you're going to use it in your school, please feel free, fair use. That's how we look at this. Okay? If you're used in any of the areas, the extension options are there on the book. Let's turn to the next page and look at the essay. Okay, you'll see here key terms and unlocking key terms. We're going to give the kids strategies to create better understanding of their reading. If you look at the reading, this is the longest essay in the entire book. It's 2 pages, 1 page front to back, next page, almost the entire front of the page. That's as long as any essay in the book is going to be. Most of them are 1 page front to back. The reason for that, we're looking at kids who don't like to read. We try to get them information they need in order to have a general understanding of this topic on 1 page, because we know that even bad readers will usually at least attempt a 1-page reading. And if you've got kids who will not do even that, you can force them in class to use this 1-page handout and read. Okay? You'll also notice there are no bold-faced words. The only things that are italicized are titles of court cases or titles of documents. The reason for that is also we want them to read. We don't want them to skim and look for the underlined or highlighted or bold-faced words. Okay? We want them to read the document. Okay? If you go to the back of the book, you will find the resources. The answer key. We answer our discussion questions for one simple reason. We expect the kids to be able to answer them, but we thought maybe we should be able to answer them based on the materials in the book. So you've got answers to discussion questions. You've got answers to anything that doesn't ask the kid for a personal opinion. You've got an answer for it back there. Okay? The reading quiz is on 221. 3 to 5 questions on each lesson, for each of these lessons. Why? How many of you have to do pre and post assessment on a regular basis? Last school I worked in, you had to do it every day. Every class had to have 3 questions at the beginning of the day, 3 questions at the end of the day. I had to report it every week to my low-level learners. Okay? That was a requirement, what I did. This is a great way to A, figure out whether or not they did the reading, okay? Force them to take these questions, or to do it as a pre and post. Give them these questions at the beginning of the day, ask them the questions, and then at the end of the day, give them these 5 questions again. Find out how many will pay any attention, because you know over half of them will not realize they're getting the exact same questions 45 minutes later. They'll think this is harder than the one you gave me at the beginning of the day. And you can say, yeah, you're right, it is. Landmark Supreme Court cases, page 245, you will find thumbnail sketches of the cases by amendment, in chronological order, by clause in the amendment. Okay, thumbnail sketches of major cases. These cases, I believe, in your book go through 2006 in this book, I think is the newest one. Every time we do a new edition of this book, we add new ones in. DC versus Heller has already been written. We actually just finished revising the guns issue, so the guns package based on DC v. Heller. Okay? Because we can no longer say the court has never ruled on what they say means, we have to say now they have. Okay? By the way, those of you who also teach English, show an English teacher the Second Amendment. Okay? If you read it grammatically, it doesn't say anything. It has 2 dependent clause subjects separated from the verb by commas. That's like saying John, comma, ran, comma, into the woods. Well, John ran into the woods means one thing. Those commas make it mean something completely different if you're reading it. If you read that thing, it doesn't make any sense. It's a string of dependent and independent clauses and an object that don't. That apparently have, it's like the way I'm talking right now. It's in pieces. I did that one time. I asked my grammatician because I know the preamble is a run-on sentence. I know they cringe every time they read it, but it's a really good run-on sentence. It makes sense. I asked them to look at the Bill of Rights and just do a grammar check on it for me. And the lady just sat there and reread circles all over the Second Amendment and said, oh my God, this makes no sense. And I thought, you just did a great political analysis of one of the pressing issues of our time and based it on English rules of grammar. You should do that in the Supreme Court. Put a grammatician on the Supreme Court. DVD guides on page 261. Questions you can look at while you're looking at the DVD, questions for after. The glossary on 269 and the educational resources on 277. Just stuff you can work with, stuff that you've got available for you. Okay? So let's take a look at lesson 1 in criminal procedure. What are the rights of the accused? This begins on page 109 or 108. Okay? What I would like you to do for me, we have some of the more famous accused in American history up here. Anybody know who these guys are by any chance? Right in the corner right here. That's Clarence Earl Gagan down here. Valley Map. That's not one of the cases I just like this guy. That's Clarence Darrow. Okay? Who's the guy with him?